Hear ye, hear ye. The First District Court of Appeals is now open. All who have business before this court, draw near, give attention, and you shall be heard. God save the United States, the great state of Florida, and its honorable court.
Be seated. All right, good morning. Welcome to the First DCA. We have one case on our calendar today, DiBernardo v. Miami-Dade County. If counsel are ready, we will hear argument in that case.
Your Honors, may it please the Court, I am Richard Sicking from Coral Gables for the appellant James DiBernardo. I'd like to save 3 minutes for rebuttal. This is an appeal from an order of the Judge of Compensation Claims denying the compensability of the claimant's heart disease. The facts are undisputed. It's paragraph 3 on page 44 of the record. It is undisputed that the claimant was diagnosed with heart disease described as severe single vessel coronary artery disease, CAD.
Okay, you got right to my first point here. Don't we normally require, in order to prove a disability, testimony or an opinion from a doctor that there are medical restrictions?
You could, but not particularly in this case, since on page 98 of the record, the parties agreed that these 3 days of lost time were those that were taken off because of the medical procedure in the hospital for the catheterization and the stenting of his heart. So that was not disputed below, so it wouldn't be disputed here.
But there's no testimony in the record that he had any medical restrictions immediately prior or immediately after the stenting was done.
That's correct. It's just this 3-day window.
Okay, so the whole question seems to be whether that 3-day window he was under restrictions, whether Bivens applies. Doesn't Bivens say that treatment by itself is not a disability?
Sort of. I think we have to look at Bivens in two possible ways. Is it a rule of law, or is it the peculiar facts of Bivens that it's a decision on those facts? Now, granted, it's hypertension and this is heart disease, but that's not a big difference. The real difference between the two cases is that in Mr. Bivens' case, there was no treatment. There was just a test to do diagnosis, which, as it turned out, was not positive. There was nothing at all for those 3 days. So factually, it's very distinguishable from this case. And that is to say, I mean, it would be absurd to say that the man in the hospital in his catheterization should say to the doctor, well, excuse me, doctor, hold your scalpel and don't make your incision. I have a phone call to take. But more importantly, the parties agreed that for those 3 days, he was medically restricted from performing work. So it is back again to the idea of 3 days.
What is the exact agreement? I haven't read that they stipulated he was incapable of working. One might assume that based upon the fact he was undergoing a procedure, but what exactly was stipulated to?
It was stipulated that, I'm sorry, I didn't finish. He was off work between May 9th, 10th, and 11th for diagnostic catheterization, cardiac catheterization, and treatment consisting of angioplasty and placement of a stent. And as I pointed out before in the record, he was asked, did the doctor take you off work any other period of time other than those 3 days? And the answer is no. The doctor took me off of work only for those 3 days.
Where are you reading from?
It was page 98 of the record.
Okay, well, help me then, because that's part of my problem.
I'm sorry.
Was the trial judge or the JCC here able to consider anything that was not directly out of the joint statement of stipulated facts?
Well, the statement of facts and the deposition that was presented, that was part of the record.
Is that clear? Because that the JCC was allowed to consider the depositions.
That was not disputed below. I don't think they would dispute that now. You may ask them.
Okay, well, I'm going to ask.
Okay.
See, you know, you have a joint statement of stipulated facts, and I wasn't sure whether the depositions could be considered.
He actually found in his order that he did consider it and that it was in keeping with the stipulated statement of facts.
But the stipulation that you read to us, that didn't go so far as to affirmatively stipulate that he was incapable of working, incapable of performing his duties as a firefighter on those 3 days.
Mm-hmm.
We would have to infer that from that testimony, correct?
Police officer, excuse me. But the fact of the matter is, one, there was the statement in the record, page 98, and we're back to, yes, is that part of the record? Answer, yes, it was. Two, I don't want to say it's silly, but it does seem that the 3 days to be in the hospital for a surgical procedure for treatment of severe single vessel stenting is very involved. So this was common sense, and the trial judge didn't find otherwise. I mean, you take the facts the way he found them to be. His determination was again back to Bivens, as though this were a matter of law, not a matter of the facts of a particular case. That is to say that lost time or the inability to work or whatever it may be for treatment is not disability. Well, it is. That's specifically what disability is.
Okay, can I get back? And I'm sorry for interrupting, but I'm looking at the order, and this is why I'm confused, because I didn't think the order specifically said that they considered depositions. It says, the facts stipulated to by the parties in Exhibit 3 are expressly adopted as the undergoing signed findings of fact. They will not be reiterated herein. Additional record evidence wholly supports the facts stipulated to.
And that was just the deposition.
That's the deposition.
That's the deposition. That's all it is.
So your position is the deposition is properly in front of the...
Yes, it was used by him.
Well, I mean, if he says that the deposition supports the facts, I mean, that doesn't mean that everything in the deposition is of the facts. In other words, the parties say, Judge, these are the 8 facts, whatever it was, however many numbered paragraphs, of this case. And he says, well, this other record evidence supports those 8 facts. That doesn't bring everything else that may be in as one of the stipulated facts, does it?
That's not the point. The point is, and I get back to the third point, which is, and I don't mean to just use the word silly, but it seems common sense, if it may be, that to be in the hospital for a surgical procedure in your heart, actually, to me, the real magic here, or miracle, if you like, is that one could have a surgical procedure for severe heart disease successfully treated and lose only 3 days from work. It is... The statute was written in 1973. I'm sure if you'd said that to someone then, they would have said that's Star Trek. That's science fiction.
I'm not getting hung up on the 7 days. It seems like there's a lot of time in the briefs argued over the 7 days.
Yeah.
That's not my issue. My issue is more that does there need to be a period of time over and above the treatment itself that the person is disabled? And I'm not sure the record supports that at this point.
Well, it certainly supports the 3 days. That's not disputed by anybody, by the
that.
judge or by us.
And I'm not hung up on 3 days versus 7 days.
Okay.
But before he went in for treatment, there's nothing in the record that I saw that supports that he was restricted from work. Now, I know he
wasn't.
Okay.
It was he had the, I mean, it's a miracle. He had the chest pains and went to the doctors. The doctor did some tests and said, ooh, you know, when they get him finally to the last of the tests, when they're preparing to do the surgeries, when they discover he has 95% occlusion of the left anterior descending coronary artery, I mean, he's in bad shape.
Yeah, they say that, you know, the extensive blockage. Now, do we need testimony, or could there have been testimony that the doctor says, well, based on that 95% blockage, that he was, should have been restricted from work?
No, we don't need that, because disability can be either permanent or temporary. Temporary, the way this legislature wrote the statute, was simply disability. There's no adjective or adverb to say of what duration or what length of time or of what severity. It's just disability of any kind or any duration. So 3 days is some duration, and that's it.
But I mean, it has to be severe enough that it makes him incapable of earning the wages that he was earning in his employment or in any other employment, right? I mean, it has to be some level of severity, and that level of severity seems to be what might be missing from the statement of facts.
Well, it's not missing here because, again, you get back to the question. Well, certainly for those 3 days, he could not have worked, and if he couldn't, and he lost the time, and if he lost the time, and they don't dispute the reasonableness of losing the time. I mean, that's stretching it to say, getting back to my example of, what was he going to say to the doctor? Hold your scalpel while I take a phone call. That's
was it in the statement of facts where he said that he took his leave time while he was?
Yeah, but that's your case. Nolan versus Delta Airlines, because if a person gets paid their own leave time, then they've been paid with their own money. And you held in that case, as we held in all cases, that if an employee gets paid leave time, their own leave, then they've been paid with their own money. So that's still a loss.
And you said that there is no requirement on the duration of time. I mean, is it, if for 10 minutes, would that be enough?
The legislature wrote a bright line in 1973. They didn't say of 3 weeks or 3 days or 8 days. They didn't make that distinction. But more importantly, I think it's a reality. Nobody's going to lose, an hour or 1 day for treatment of severe heart disease. That's unreal. The real miracle here is that it's possible to do this in 3 days.
If he had treatment on Friday, Monday was a holiday, he would have missed 1 day of work. Right?
Well, we're not here about if one, but the fact of the matter is the legislature wrote a bright line. It's like a statute of limitations is not 1 year and 1 day, it's 1 year. So here it's any disability. They did not qualify it.
Okay, since you agree he was not entitled to any impairment benefits, wage loss, whatever we want to call it, so just, and I'm not sure it's in the record, but just for my edification, what is this fight really about?
Medical care. In 1973, when the legislature made the presumption applicable to workers' comp, before that it was only applicable to pensions. So when they made it applicable to workers' comp, the main thing that they did by doing that was making the medical care available. That's the issue. So anyone who suffers, who otherwise qualifies and who has it isn't just the disease.
Okay, well, help me with there, too, because obviously Dade County police officer is going to have health benefits as well. So when you say you're arguing about medical benefits, we are arguing about co-payments here? Is that what the whole argument comes down to?
No, it isn't just the co-payments, but that's part of it. Yes, that's part of it.
Okay.
The statute was made applicable to this class of persons for medical care in 1973 so that it would be covered by workers' compensation. There's a big difference between the continuing obligation to provide medical care under workers' comp and group insurance, which is just during the period of time that the policy is in force. So there's a big difference. It isn't just the co-payments. It's also the availability of the medical care period.
Okay, we're also talking about the period of the statute of limitations starting to run, too. So it's a limited period of time that we're talking about as well, aren't we?
Yeah, there is. Yeah, it certainly would become limited by all the other things in the workers' compensation law, whatever they may be.
Do I understand the chronology correctly that on the 9th was a diagnosis day to get the stent? The 10th was the treatment day to get whatever happened on the 10th. And maybe I'm using my medical terms wrong. The 11th was a recovery day, and he was back to work on the 14th?
Yes, on the 14th. Yeah.
So I guess my question would be if you said we're talking about 3 days, if Bivens was talking about a diagnosis not being a disability, wouldn't we really now be talking about 2 days, the treatment day on the 10th and the recovery day on the 11th?
Well, that's what I meant about the difference between law and facts. If you look at Bivens, and that's why those of us who are down on this side are perhaps a little confused by it, because if it's fact-specific, because it was a case about the facts, the man basically had a diagnostic test, as you say, for 1 day that proved to be negative. Which is quite different from here, where the man not only has the diagnosis, but also a treatment for a condition which is very severe and life-threatening. So it's two ends of an arch or a rainbow. So I can't say that there's a comparison there.
But if we talk about the facts of Bivens, then realistically, there was never any testimony in Bivens, and Bivens himself testified that he was never prevented from working, and no doctor had ever told him that he was prevented from working. The doctor said later it might have made good sense while we didn't know not to work, but he was never had the medical restrictions that seem to be missing here as well. No doctor's testimony that says because of this you can't work.
But again, when we were below, that was never disputed here.
But the JCC...
We can't create defenses here and make things, and again, it wouldn't make sense. So, but this to compare Bivens, who basically isn't sick, with this man who has a condition which is, life-threatening, is simply no comparison. The real issue is, this case highlights, I suppose, more than any other, because the facts are undisputed, and we can't make disputes that aren't there, that what period of time does it take when the legislature said disability and didn't qualify it? And for these diseases, it would be hard to imagine a period of time if you have the disease and it causes some loss of ability to work, some lost time, and in this instance, some lost money because he got paid with his own money, then that makes it compensable as opposed to the disease itself. We're not here to try and say, oh, well, the legislature was right. But all three of the conditions are simply diseases that begin microscopically, nothing. At some point, they're going to produce symptoms, still nothing. But when they become serious enough to cause the employee to lose, then they become covered.
You're welcome to continue, but you've got about 30 seconds left. I'll give you another minute when you get back up.
I think we're clear. Thank you.
Thank you.
Good morning. May it please the Court. My name is Douglas Rice, and I represent the appellee, Miami-Dade County. What the case is really about is reversing long-standing precedent by this Court, going back to Sadaka, Connor, Mickles.
Before you get into that, I sit here and I wonder, I had some cases yesterday and I wonder about the cases today. If all we're arguing about is medical benefits, why is the county taking all this time, spending as much money arguing this out, taking the court time? What are we doing here?
Well, we're basically following the law. The Court has said, and this Court has held repeatedly, that just because you're diagnosed with a potential occupational disease or any of the qualifying conditions under 112.18, it's not compensable under workers' compensation until there's some incapacity.
But we also have case law, though, that's saying, I think it was hepatitis cases, where somebody, as a result of hepatitis treatment, was unable to work. And I'm sorry, I thought I had the cases in front of me, and I was trying to look at it.
I think it's McWhorter.
Jones, I think, and Michaels.
Right.
We said hepatitis treatment, which resulted in missing work, was sufficient to create a disability. I understand the treatment time itself arguably isn't, but if we know there's a disease and the treatment causes some period of disability, why shouldn't that meet the statute?
Because the definition of disability in 440.02.13 is the incapacity to earn wages in your current employment or some employment that you were doing prior to the actual injury.
Okay, but the period of time, at least when he was under getting the stint done, that was, you concede that he could not at that point do his employment or do his job.
I presume that if he's being catheterized, he is under anesthesia, incapable of doing almost anything.
So why would that not satisfy the definition of a disability, since it could be, it could be temporary?
Because this Court, I guess logically you can say that, but we're creatures of law, and we're following the law, and we're following what the legislature has told us to do, how this Court has interpreted it.
Okay, well, say what the legislature has told us to do. I'm not sure the legislature is totally clear on what they've told us to do here. And are you referring to any other law other than Bivens that says that this cannot result in a disability?
Well, I'm not sure I'm following the question.
You just told me that we need to follow the law. My question was, why wouldn't the period that he was under, you've conceded that he can't work while he was under during the catheterization and the putting the stent in. Why would that not satisfy the definition of disability? And you started out saying the legislature told us and this Court has told us. What I'd like you to tell me right now is, where has the legislature told us that, and what case law has specifically told us that the period he was under actually getting treatment for this blockage is insufficient for the disability, to establish a disability?
Well, in Bivens, this Court said that treatment evaluations don't necessarily equal incapacity or disability for purposes of compensability under Florida's workers' compensation law.
Okay, but in Bivens, there was no disease discovered.
Well, there was a micro-valve condition in Bivens. There, if I'm recalling correctly, there were two conditions.
There was no, I guess Judge Walsh's point is there was no treatment that flowed from whatever condition was found. maybe that's the question. Is that, counsel distinguished Bivens based upon the fact that nothing flowed from the diagnosis. Here, something flowed directly from the diagnosis, the treatment, that resulted in him, as you can see, being unable to work for at least the period of time he was being treated and on recovery, correct?
But Bivens, I believe, also underwent treatment and lost some days, at least one day for a doctor's appointment and several days for treatment, unless I'm confusing it with Nichols. But
I think Bivens lost a total of 6 days, actually.
Right.
But I mean, there's also Brown v. Florida Power, which was another occupational disease case where it was diagnosed, but it had not resulted in any disability because Brown was still able to go to work. In other words, his condition did not result in a doctor saying, because of this condition, you are unable to work. And isn't that the definition that we find in 440.0213? A disability, there has to be an inability to work because of the condition. And Mr. Brown didn't have it in Florida Power, and Mr. Bivens didn't have it in his case.
Correct, nor did Nichols have it, and nor did it exist in several other cases, including Sadaka. And
Okay, well, Brown might be distinguished, and Bivens might be distinguished, and help me here. We have, as part of the stipulated facts, that there was a severe blockage in a major artery to the heart that he immediately had to have treatment for. Can we not infer from that that if the doctor had known that, this man was incapable of performing the full job duties of a police officer? I mean, they wouldn't want him out wrestling a guy on the ground with this severe blockage, I guess.
well, I presume many of us walk around with certain ailments and stuff that aren't diagnosed until we actually exhibit symptoms, as in this case when he went out jogging and felt the chest pain and went to the doctor and said, yes, you have a blockage, you need to go in for a cath, and you need a stent. That happened over a relatively short period of time. He didn't meet the minimum period of time for...
What if he had been taken out for 1 day prior? The doctor said, well, you can't work because you have a severe blockage. I can't do it today. We'll monitor you, and we'll do the treatment on Monday.
Well, I think Mickles' doctor said, the EMA in that case, or if it was the EMA in Bivens, that in retrospect, it would have been a good idea while he was undergoing the treatment not to work. But that retrospective opinion about whether or not it was a good idea is not necessarily evidence of an incapacity to perform your job.
So if in this case we had a finding from the JCC inferred out of the deposition, I guess would be the only place he could do it, that Mr. DiBernardo, Officer DiBernardo, was incapable of performing his duties as a police officer because of this condition, we wouldn't be here having this case today, would we?
Well, I don't think the JCC would be correct in that kind of determination because there would be no evidence to support it. I mean, you just have under the current cases as they exist, I don't know how the JCC can infer under the stipulated facts that he was incapacitated or incapable of performing his jobs, or could say under these facts.
I mean, you're talking about magic words here, but when we're talking about a severe blockage of the heart, doesn't common sense tell us that that is going to make someone incapable of performing all the full duties of a police officer?
Well, I guess we can make a lot of presumptions about medicine, and not being a physician or a cardiologist myself, I don't know necessarily how to answer that in a scientific way, if you will, other than the fact that, every disease is potentially life-threatening if it's left untreated and allowed to progress. Fortunately, in this case...
You have to wait for the guy to have a heart attack for it to be disabling.
I'm sorry, Your Honor?
You have to wait for an actual heart attack before it's disabling.
No, sir. You have to wait for an incapacity or an inability. You have to have a doctor who says you can't work because of this condition.
So it comes down to the magic words from a doctor.
I think.
I mean, in all cases. I mean, it might be, but I'm just trying to find out where we are. Does it come down to the magic words of a doctor?
Well, I don't think that a claimant can state on his own that I'm disabled. I think these kind of conditions, internal failures, traditionally have been dependent upon an opinion of a medical expert to determine what they are and whether or not they're disabling.
Okay, if we are relying, we have to look at the doctor's testimony, then let me get clear, because I wasn't sure that I was clear in reading the order and the stipulation. Was the deposition properly considered by the JCC? Was that part of your stipulation?
The Was it part of the stipulation? The deposition was merely entered into evidence in support of the stipulated facts.
Okay, so the deposition was properly in front of the court.
Yes.
And that was the deposition of the claimant?
Yes, sir.
But, well, how about the doctor?
There was no deposition of the doctor.
Was there any
There was a
I'm
report.
sorry.
There was a report from the doctor that said he was released to return to work without restrictions. And that followed. That was on the 14th. He felt the chest pain on Tuesday, ran on a Saturday, felt the chest pain again. He worked during this entire time, from the first chest pain experience to the second chest pain experience. He went to the doctor on Monday. The doctor scheduled an appointment for April 30th for him to be evaluated by a cardiologist. He was referred for a stress test, but the Baptist Hospital had a stress on the 9th. He was admitted on the 10th. The angioplasty was performed. The stent was put in the artery. He was released on Friday. He stayed home on Saturday and Sunday. He went back to work on Monday, which was the 14th. The doctor wrote, when we asked the doctor what his diagnosis was, the claimant's diagnosis was, and whether or not he could work or not work, or if he's disabled, he said he would return to work with no restrictions as a police officer. So that's a good outcome.
Let me try my question again. If this JCC found, if the findings in his final order said, and I understand the second part of my question coming later, there may not be evidence to support it, but if the JCC had said, as a finding, factual finding, that the officer was incapable of performing the duties as a police officer because of his condition, we wouldn't be here. He would have been disabled and been receiving the treatment. Correct. Well, I guess you would have been providing benefits. We'd maybe still be here. But I mean, you understand my question? I mean, if the JCC had made the finding he was incapable of performing his duties, you would agree he would be disabled.
Well, can I restate the question so I can understand? Sure. If that report that we got from the doctor, Dr. Casueda, who was the cardiologist, said, instead of he's released to return to work without restrictions, he was incapable of performing his duties for the 9th, 10th, and 11th while he was undergoing this procedure, my response to that would be, this is treatment under Bivens and Mickle and all the preceding cases, Sadaka, and it is not incapacity to perform his job or to earn wages. There may be a wage loss, but there is not an incapacity. You have to have an incapacity with a wage loss in order to have a disability for it to be compensable. I think it's the only thing I can say is that's what this court has said. That is how we've adopted this court's reasoning and interpreting these statutes. It's been difficult, but I think we're correct in that Mr. DiBernardo falls squarely within the boundaries of Bivens, Mickles, and Sadaka, and his case is not compensable. He either meets the requirements, as this court has said in Sadaka, of the statutory provisions, or he doesn't meet the requirements.
Let me rephrase one of the earlier questions that you were asked. I mean, wonder if the doctor, instead of writing his report on Monday saying he's released now on Monday with no restrictions, had written the previous Tuesday, because of the results of the stress test, he is incapable of performing his duties as a police officer until such time as he has treatment. He writes that down on Tuesday, and then he has the treatment, and it goes really great, and Monday he's back at work. He then would have had the medical testimony prior to having treatment that his condition caused him to be incapable or, prudently incapable. Maybe he still could have gone to work and performed without an adverse incident, and that would be great, but prudently he would be incapable of performing his work. Then would he have qualified as a disability?
Well, I guess hypothetically you could also say that the doctor could have written a note saying,
well, let's not, I mean, if the doctor, just assume my hypothetical, yes or no, would he have been disabled if the doctor, prior to doing the surgery, said, I have done a stress test, my medical opinion is he is disabled, he is incapable of performing his work because he has this condition with his heart, and I want to treat it before, and see how treatment goes before he goes back to work? I mean, just like a broken arm. I want you off work for 3 days. I want you on your couch. I don't want you to, and then come back and I'll check you out. And hopefully everything's great and you go back to work.
Under the status of the cases now, our position would be that he could potentially be disabled, but if after the treatment the doctor says, listen, we've treated him, there's nothing wrong with him, or even if there is something wrong with him, he's not incapacitated, he has no disability, he can return to work full duty.
So he may have reached maximum medical improvement.
How about the question, you keep on ducking the question though, is how about if the doctor had said, he is incapacitated today, I'll perform the surgery tomorrow. He cannot do any work today.
Does that rise to the level of incapacity or disability under 440.02.13? No.
Why not?
Because we go back to the argument or the holdings in your cases that you need to have the incapacity to earn wages. He never suffered an incapacity even for the...
You keep on ducking the question. If the doctor had said he is incapable of earning wages, he can't perform all his duties as a police officer, and tomorrow I'll perform surgery. But right now, for this one day, he is incapable of performing his duties as a police officer. Would that meet the definition of a disability?
Well, I guess by definition, yes. He is disabled for that one day.
So, a poor police officer who doesn't have a lot of money, that's talking to his lawyers, goes in and says, well, okay, perform the catheterization, let's see what's going on in there, but if I have to have further surgery or I have a condition, let's hold off for 24 hours for doing it, because I don't want to be responsible for 20% of my medical bills. I mean, is that what we're coming down to here?
I'm not sure that I follow the question. Is this an attempt
Well, the question is, does he need to get a doctor to say that for the 24 hours, or, wait 24 hours, and for that period of 24 hours, he's incapable of performing his duties as a police officer?
Well, if the doctor says he's incapable, we're not going to make him go back to work when he's got a compensable condition. If he's got a heart disease and he can't go back to work.
Well, what if this doctor had said in this case, clearly, in at least the 24 hours before he had this condition, that he was incapable of performing his duties as a police officer? What if we had that opinion on the record here?
The doctor states that he's incapable of 24 hours before. And the question is, that rise to the definition of disability?
No, I'm saying doctor went in and said, based on the condition I found here, clearly, in at least the 24 hours prior to me doing the stint, he was incapable of performing his duties as a police officer. Would that have satisfied the statute?
The statute 112.18?
Yeah.
I don't think so under Bivens.
All right, counsel, thank you.
Thank you.
All right, Mr. Sickling, 2 minutes.
Okay, Mr. Sickling, I have to ask you a question. And it might be a little bit embarrassing, but I'm going to ask it. Did you fall one question short with the doctor here?
No.
Why not?
Because, one, having agreed that with this condition he had the 3 days of lost time, the party's not contesting that it was for the medical reasons that he was incapacitated from working. Two, because that's common sense. And three, as I pointed out before, page 98 plainly stated in the record, which the judge had to consider, that the only time that was taken off at the doctor's orders was the 3 days. So I guess we could even say a fourth one, and that's certainly a reasonable interpretation of their statement, which, by the way, was to horse the record, but I don't dispute it, which was that he was released to return to work on Monday because we have the lost time beforehand.
Would you agree that perhaps if there were a sentence in the stipulation that said that he was incapable of performing his, the parties agree that he was incapable because of his condition of performing his duties, that it would have been better?
I'll agree to that. But I also will agree that since they don't dispute the point below or here, even in everything they said. They never disputed that he was incapable. I mean, it would be silly to contend that he couldn't work for whatever short period of time. Whether it's 1 day, 2 days, 3 days is really not the point. Because
it may be silly, but if what we're looking at is the JCC's order, which incorporates the stipulation, if we find that to be, the dispositive factual issue and it's not in there, aren't we constrained to affirm, even if it is silly?
I don't think so. I don't think you're constrained to do silly things. Okay, I understand what you're saying, but at the same time, we have to address things the way they really are. And indeed, in his order, he didn't address that. So if you want to say, well, that's a finding of fact he didn't make and should have, because what he said was an error of law, not an error of fact, where the error of law is that being unable to work for medical reasons is not disability.
Help me here also on this question of the extensive blockage. Can we as judges look at that and say, I don't know what an extensive blockage is. Is it a 98% blockage? What kind of physical incapacity does that cause? I think in my heart, bad choice of words, but that I think I know what that means, but aren't I jumping into the field of medicine if I try to say this clearly would have made him incapable of working?
Well, if you did that in Bivens, then you've done it here. The fact of the matter is that wasn't something they disputed. So there's, we do sort of have this rule, if it's not disputed below, we can't start disputing it here, and we don't need to.
Well, I think they're not going to dispute while he's on the table he was disabled, but I'm not sure that they've agreed that immediately prior to going on the table.
No, we didn't. The immediately prior isn't necessary. Let's go back to 1973 when the legislature made the medical benefits available for workers' comp by deleting the words at the end that it wasn't available to workers' comp. They could have, but didn't make any distinction about the disability as to whether it was permanent or temporary, total or partial. It's just disability without any qualification. So it may seem silly that it can only be 1 day. But that's a bright line like a statute of limitations. That's the legislature makes the laws. But beyond that is the simple truth that for any kind of serious injury, which this man had and Bivens and other cases did not, is if there is any disability, and here there was some, it triggers the medical benefits. That was the legislature was distinguishing between those diseases which don't cause death or have no disability. As to the point when they do become disabling, then the medical benefits become available. And that's what the case was about. Thank you, Your Honors.
All right, we will be in recess until